we are covering the multiple types of powers of attorney, or POAs, as tested on the Arizona Notary Public Exam. A power of attorney is a written document where one person, the principal, appoints another person as an agent to make decisions on their behalf. For the exam, you must know that all POAs in Arizona require the principal's signature to be notarized. The core issue for a notary is always verifying the principal's identity and ensuring they are signing willingly and with full understanding. The most critical point, governed by Arizona Revised Statutes Title 14, is that the principal must be competent and of sound mind at the time they sign the document. If the principal later becomes incapacitated, a durable POA allows the agent to continue acting on their behalf. This is a common exam trap. A question might describe a scenario where you are asked to notarize a durable POA for a principal who is already incapacitated. You must refuse, because competency is required at the moment of signing. A durable POA is only durable after a valid signing. To be durable in Arizona, the document must contain specific language, such as, "This power of attorney is not affected by subsequent disability or incapacity of the principal." Without this wording, it's a non-durable or general POA, which automatically terminates if the principal becomes incapacitated. A general power of attorney grants broad authority to the agent to handle financial and business transactions. In contrast, a special or limited power of attorney restricts the agent's power to a specific transaction, like selling a particular piece of real estate. The exam will test your ability to differentiate these scopes. For instance, an agent with a real estate POA for a specific property cannot use that authority to manage the principal's bank accounts. Another distinct type is the Health Care Power of Attorney, which is strictly for medical decisions and is governed by Title 36 of the Arizona Revised Statutes. As a notary, your role isn't to interpret the document's powers, but to ensure the foundational requirements of the notarization are met. This leads to another major exam topic: refusal to notarize. If you suspect the signer is being pressured by family or doesn't understand the document, you have a duty to refuse the notarization. An exam question might present a situation where a family member is speaking for the principal or seems to be coaching them. In this case, the correct action is to politely refuse and document the reason in your notary journal. Remember this phrase to stay on the right side of the law: capacity at signing is king. This mental shortcut reinforces that no matter what type of POA it is, durable, general, or special, the principal's competence at the moment of notarization is the absolute, non-negotiable requirement. While Arizona has statutory forms, their use isn't mandatory, but any POA document must meet the state's legal criteria, including being signed before a notary and a witness who is not the agent's spouse or children, or the notary themselves. For free practice questions, AI-powered explanations, and more exam prep tools, visit openexamprep.com. That's openexamprep, all one word, .com.